Hello guys, welcome to the channel. Today I am dictating you 540 words at the rate 80 word per minute. So let's get started. 3, 2, 1 and go. This was based on the reasoning that a direction for reappraisal of evidence would create an unconscious impression in the mind of the trial judge that the High Court wished the lower court to reach a particular conclusion and would also complicate the issue in the given situation, where a large number of persons were involved but no evidence existed against most of them. The High Court further proceeded to observe that the trial court had reached a finding of acquittal upon a consideration of the probative value of the evidence on record, in accordance with set canons of law and upon a meticulous examination of the same. Certain general observations relating to the revisional powers of the High Court were adverted to by the High Court while coming to its conclusion. Practically, the High Court has not touched the case of the prosecution on merits, at least prima facie, to find out as to whether the trial court's reasoning is just and proper or not. We have heard learned counsel on either side. Before proceeding further, we would like to decide the preliminary question that arose during the course of arguments regarding the scope of interference by this court with a judgment of the High Court in exercise of its revisional power, affirming a conviction. The question is no more res integra, inasmuch as this court, in the case of Dharam versus Nirmal Singh, has held that the bar under section 401 under bracket 3 does not restrict the power of the Supreme Court under Article 136 of the Constitution. While concluding so, the following observations were made: before we record our reading of the evidence produced in the case, let a legal submission advanced by Shri Lalit, appearing for the respondent accused, be dealt with. His submission is that as the complainant had approached the High Court in revision and as under the revisional power available to the High Court under Section 401 CRPC, the High Court could not have altered the finding of acquittal into one of conviction because of what has been stated in subsection under bracket 3 thereof. If we were to be satisfied that the acquittal was wrongful, it would not be within our competence to convict the respondent. At best, the case could be sent back for retrial. We are not impressed with this submission inasmuch as the approach to this court being under Article 136 of the Constitution. We do not read the limitation imposed by Section 401 under bracket 3 of the Code qua the power available to us under the aforesaid provision. May it be pointed out that a similar submission had been advanced by Shri Lalit himself in the case of so and so versus State of Kerala, then contending that this court is incompetent to issue rule of enhancement as had been done in those cases. It was held in the aforesaid decision that The power available to this court under Article 136 is not circumscribed by any limitation. In any case, power under Article 142 is available to pass such order as may be deemed appropriate to do complete justice. We therefore reject this contention of Shri Lalit and proceed to examine the materials to find out whether case of conviction does exist as the contention of the appellant. Full stop and over. Thanks for watching. Please do like, share and subscribe the channel for more dictations, and don't forget to press the bell icon for future notifications.